Maybe you can talk about some of the kind of best practices, whether you're an independent inventor or a large company or a small company. What are some of the things that you should be first be doing in terms of protection?
Whether you're a small inventor or a large company, you always have the same general issues, which is first and foremost identifying what you have. If you don't understand what intellectual property you have, if you don't have an IP inventory, it's going to be very difficult for you to take the approach of defending it against anybody or even protecting yourself against allegations. Getting a good understanding of what you have is important. One thing I heard earlier that I liked a lot, kind of a saying I give to everybody, and that's nobody steals a bad idea. Now, that's not necessarily true, but the fact that you're being infringed isn't necessarily a black mark. It's a problem that can be addressed, but it shows somebody is seeing some value in what you're doing. Of course, there's cost associated with that, and there's ways to mitigate costs, there's ways to mitigate infringement. It's a very complex area, but little things like obtaining intellectual property coverage insurance, like there's an intellectual property insurance services company out of Louisville, Kentucky, and I've litigated cases under their policies, and it made the difference between little companies staying in business or big companies just winning because they outspent the other side. But uh, identifying what you have, making sure that anyone that's participated in the project has signed over whatever patent rights they may have, being very, very careful with suppliers and vendors. Most of the patent litigation I get involved in is because somebody along the product development road saw the value and decided to file on somebody else's patent. And that can be very difficult, very expensive, but it's easily avoided with just having the right agreements in place and having everybody on the same page as far as what everybody's rights and responsibilities are. And that's critical.
Yeah, excellent points. It was me that said, yeah, it's a good problem to have, right? Infringement is a good problem to have because it means that you have something worth copying. James, kind of same question to you. What do you think kind of best practices early on that you've seen that people should or shouldn't be doing?
Yeah, I'll echo Jim's sentiment. And the phrase I use often is getting knocked off is the hallmark of a good idea. Because, as Jim say, it's not always true, but
Yeah.
if you have something, and people want it, that's what ends up happening. Whether it's, someone on Amazon or Etsy, or it's a more sophisticated entity elsewhere, having that idea is something that is attractive to people. It shouldn't be all doom and gloom, but the mindset should be, well, now what do we do about it? We have the IP hopefully secured by that point. And so since we have the IP secured, we have something to enforce right at that point. If you don't have that, you still may have a cause of action, but it's probably not going to be for patent law, right? Or a patent infringement. It's going to be maybe a potential other theory, depending on if they violated a contract with you, as Jim alluded to, down the supply line and what have you. So that's definitely something to keep in mind in terms of just how you approach the matters, because I do think having the correct mindset and understanding what's in front of you does help make things more palatable and understandable for you. If you're walking into a litigation with a doom and gloom mindset and woe is me, I think that's putting you off on the wrong foot to start, and that's not going to bode well for the future. Outside of that, Jim mentioned the insurance, also litigation funding from third parties is a good option as well that can fill a gap there if insurance for one reason or another isn't an option or isn't something that you have at that point. And I'd also encourage individuals out there, you don't necessarily need litigation funding or have any deal lined up prior, but you should investigate those entities. You should understand who they are, what they do, and generally how they could interact, with your company. Because when it hits the proverbial fan, again, it's good to be prepared, right? It's good to have, some idea of who you need to contact or what you need to do in order to move it forward in a effective and a timely manner. Because there are deadlines and there are things that need to be done in such a way that you don't find yourself, behind the eight ball trying to play catch up rather than offense, particularly if you're on the enforcement side of things, right? You don't want to constantly be reacting. You want to be proactive in terms of how you approach your IP and enforcing the IP.